I'm Alonzo Martinez, Associate General Counsel at HireRight, and welcome to the last chapter of the Compliance Playbook, our 2025 Compliance Year in Review. I'm glad you're here. Quick note before we dive in. While I'm a lawyer, today's webinar is not legal or compliance advice. My goal is to give you clear, practical information you can take back to your teams and discuss with your legal counsel. And while you're here, feel free to scan that QR code on the screen and connect with me on LinkedIn. I post short compliance updates every week breaking down what's changing and why it matters. A few quick housekeeping items before we get started. To receive HRCI or SHRM credit, you need to attend the full live session. Credit details will be emailed next week along with a link to the webinar recording. We aren't distributing the slide deck, but again, you'll get a recording. If you run into any audio or video issues, try refreshing your browser by pressing F5 on your keyboard or use that Q&A icon for help. Sharon is producing today's session and is monitoring the feed for any technical issues. After the webinar, please take a moment to complete our brief survey. Your feedback directly shapes future sessions, and I genuinely value your input. One more thing, we're continuing our live and after hours Q&A today. My friend and colleague, Nicole Campion, is answering questions in real time. Keep her busy, get those questions in. We're gonna host a short Q&A session after the main presentation to recap everything and cover anything that we didn't get to. So stick around for that live after hours session if you can. Before we jump into the details, let's take a step back and look at the year we just survived. 2025 was not about minor adjustments. It was what I'd consider a year of recalibration. Compliance expectations, they shifted from best practice to baseline. States moved quickly to modernize longstanding systems, especially around criminal history and pay equity. Clean Slate legislation accelerated, and with it, employer expectations changed. At the same time, AI laws spread rapidly across the country. Each state brought its own definitions, disclosure requirements, and enforcement models. Employers found themselves managing overlapping obligations and in some cases conflicting ones. Meanwhile, the federal government made it clear it views state-level AI regulation as a problem, setting the stage for what I consider a growing preemption fight. Layered on top of that were expanded pay transparency rules, tighter cannabis testing limits, and renewed friction around I-9 E-Verify and work authorization. Compliance last year, I wouldn't say it was a check the box exercise. It became more of an operational imperative, something that you really had to closely watch. So today we're going to break it all down, what changed, where it's headed, and how to keep your screening program not just defensible, but ready for what comes next. And here is the game plan. I'm going to walk you through the most significant developments from 2025. We're going to move quickly, but I'll keep the takeaways clear and actionable. You're going to find helpful links in the resources icon of this webinar. Check out that resources section. It includes our companion Forbes article, 2025 Background Screening Compliance, What Employers Must Know. You're getting early access to it today. It's going to go live on Forbes Friday and on the HireRight blog shortly after that. It covers everything that we're going to cover today. So make sure and keep that handy. Great for note takers. If something sparks a question, drop it in the Q&A. Nicole, again, is here with me live, and we're going to continue the conversation during our extended Q&A at the end. And if there's a topic you want us to cover next time, let us know in the survey. I read every single suggestion, and you're always welcome to drop me a line on LinkedIn. So let's get into it. We're going to kick off the compliance playbook with criminal history reform. And there's a reason that we always start with criminal history reform. Even after years of legislative activity, this is still the area where employers feel the most operational pain. This section is really about one question. How do you screen responsibly when the rules about when you can ask and what you consider and how you can act all depend upon where the job sits and who you're hiring? Spoiler alert, work location really matters here. Let's start today with ban the box laws, because this is the foundation of criminal history compliance today. What you see on the screen is a color-coded snapshot of how jurisdictions regulate the timing and use of criminal history. And the first thing to notice is this. Every jurisdiction listed delays criminal history inquiries until later in the process. None of them allow you to ask up front. Now, the red jurisdictions go further than many employers expect. These rules don't just apply to traditional employees, they extend to contractors, freelancers, gig workers. If you pay someone to perform work, then they're covered. In Aqua, you see jurisdictions that require a pre-adverse action notice tied to the specific criminal offense. This is where that generic pre-adverse action language, that all breaks down. Employers have to identify exactly what record is driving that proposed adverse decision. In blue, jurisdictions require a formal individualized assessment. That means that you can't rely on blanket exclusions or informal judgment calls. What's an individualized assessment? You have to explain why a specific offense matters for that specific role. Then there's that purple or wine-colored column. Places like Los Angeles and New York City, they add local mandates on top of state law, city-specific notices, city-specific forms, city-specific timing rules. Some jurisdictions don't technically ban early inquiries into criminal history, but they still demand individualized assessments of that criminal history. Wisconsin is a common example. Madison adds its own ordinance on top of state law. Louisiana and Atlanta, they also fall into that category. So what's the takeaway? Well, the takeaway here is practical. Ban the box is not one law. It is a local patchwork. Hiring workflows, application language, adverse action notices, they all have to flex based on that geography. Again, work location is particularly important. Philadelphia is a great example of how quickly this risk can escalate. Starting January 6, 2026, the city's revised ordinance dramatically tightens both look-back rules and the adverse action process. Misdemeanor convictions older than 4 years are off limit, even if an employer believes that they're job-related. Summary offenses like disorderly conduct or loitering completely prohibited, and expunge or seal records must be ignored even if they appear in a background report. The last point matters in practice. Employers can't assume that because something shows up, it can be used. You have to understand that criminal history and its timing. Philadelphia also formalizes a provisional adverse action step, pre-adverse action step. Employers have to issue a written notice, identify the records at issue, and give applicants 10 business days to respond with evidence of error or rehabilitation. And 10 business days to respond. Here's the piece that really changes behavior. If an employer takes adverse action within 90 days of a protected activity, such as a candidate requesting a copy of their report or asserting their rights under the ordinance, the law creates a rebuttable presumption of retaliation. What does that mean? The candidate can say that you retaliated against them if you take any adverse action within 90 days of them asserting their rights under the ordinance. What does that mean? Well, that means speed becomes risk. Philadelphia forces employers to slow down, document their reasoning, and treat adverse action as a compliance event, not as an administrative checkbox. A quick aside, employers are supposed to provide a notice of rights under the ordinance, but the Philadelphia Commission on Human Relations has yet to publish that notice. I've been communicating with the commission, and I understand that a notice is forthcoming. It's just delayed. So what do you do in the interim? Well, continue performing your individualized assessments, and let's await possible enforcement guidance. I hope it's coming. I'll, of course, keep you updated on LinkedIn, and our HireRight customers will receive a notification with any developments. More's coming in Philadelphia, I promise you that. Washington State shows a different kind of shift. House Bill 1747 expands the Fair Chance Act and changes the sequence of hiring decisions. For larger employers, it takes effect July 1st, 2026. For smaller employers, January 1st, 2027. The biggest change is timing. Criminal history moves to after a conditional offer. If your process screens earlier, even out of habit, you're going to need to adjust. For most employers, it's probably not a big deal. The law also tightens decision-making. Arrests and juvenile records are off the table. Adult convictions require a job-related justification supported by an individualized assessment that looks at severity, time passed, and rehabilitation. If an employer revokes an offer, the candidate has to receive a written explanation and be given time to respond. What often surprises employers is that this law extends to current employees. So discipline and termination decisions, they now fall under that same fair chance framework. This isn't just about hiring practices, it affects workforce management, your documentation, and your internal training. Kansas City gives us a glimpse of where fair chance laws are headed. The city added criminal history status as a protected characteristic under its civil rights code, at least for public employers. For private employers, the ordinance leaves open questions. It doesn't clearly mandate individualized assessments, but it signals how criminal history is being reframed as a civil rights issue. So what does this mean? Well, Kansas City already has a ban the box ordinance delaying inquiries until after interviews. This new law creates uncertainty about future enforcement expectations. Do you need to conduct individualized assessments? Maybe, maybe not. But in situations like this, waiting for perfect clarity from the city, that's risky. What I think is individualized assessments remain the safest approach. They align with the EEOC's guidance and they prepare employers for how these laws tend to evolve. So in Kansas City, just conduct those individualized assessments. Minneapolis takes this concept even further. As of August 1st, 2025, justice impacted status. It became a protected class under the city's civil rights ordinance. The definition is broad and it includes arrests, charges, convictions, incarceration, probation, and parole. You can still conduct background checks, but you can't base decisions solely on criminal history unless the offense is job-related and supported by a six-factor assessment. You can see those six factors there on the screen. Remember, Minnesota is also a ban the box state. So Minnesota state law controls when you ask after a conditional offer. Minneapolis controls how you use what you learn. Because justice impact status is now a protected class, the stakes here carry discrimination risk, not just procedural risks. That raises the stakes considerably. So make sure you run your individualized assessments here in Minneapolis. Wisconsin and Madison illustrate a different compliance challenge. Neither law bans the box. Employers can ask about criminal history. The restriction comes in how that information is used. Under state law, a conviction must be substantially related to the job. Arrest records generally can't be considered. Madison adds an extra layer by requiring employers to consider an applicant's character. The ordinance doesn't define the term, which creates uncertainty. In practice, that means documenting rehabilitation, work history, and conduct since the offense. Individualized assessments, they're going to become a practical standard in Wisconsin and in Madison, in fact, even when the law doesn't use that exact phrase because of this concept of character. Document anything that relates to character for Madison, Wisconsin. Now, let's take a step back and talk about clean slate laws at a high level. Clean slate laws change what employers see in the first place. Once a record is sealed or expunged, it drops out of public access and it stops appearing in background checks. Most states now offer some form of automatic record relief, and many are shifting towards these automatic processes that require no action on the part of the individual. Automatic record relief is now becoming the gold standard. In 2025, that trend accelerated. Minnesota, Colorado, Hawaii, Virginia, and Washington, D.C. are all expanding automatic sealing or expungement. Implementation often lags behind effective dates, and records tend to disappear in batches. For employers, the practical impact is this. Background reports are going to change over time. They're evolving, sometimes without warning. Fewer criminal records will be reported as a result of these clean slate laws, so it will be less criminal history for you to consider. Let's bring this into sharper focus. Starting in 2029, Illinois plans to automatically seal millions of records through a state-led process. Many records that once appeared are no longer going to be reportable. That means employers in Illinois, they can't rely on old assumptions about what records will show up or how long they remain visible. All of that's going to be changing the next few years. Expect to see more details out of Illinois before the 2029 effective date. I'll, of course, be covering that for you. So let's tie this all together. The biggest mistake I still see is treating criminal history reform as a single compliance problem with a single solution. That approach, that no longer works. Philadelphia rewires adverse action and look-back periods. Remember, 4 years for misdemeanors, 7 years for felonies, no summary offenses. Washington, they flip screening timing after a conditional offer. Kansas City signals civil rights risk. Minneapolis elevates criminal history into a protected class. Clean slate laws quietly erase records in the background, often leaving a gap between the effective date and when the court actually gets to delimiting those records, presenting in many cases compliance challenges for you as employers. The common thread here is process discipline. You want clear workflows, trained teams, individualized reasoning that you can explain on paper clearly. The employers who succeed here, they're not chasing laws, they're building systems that can adapt as the rules keep changing. That's the real compliance playbook lesson for criminal history reform. And from a HireRight perspective, we have several tools that can help you manage your compliance responsibilities. From our free compliance workbench solution that flags criminal history subject to a ban-the-box law and allows you to conduct individualized assessments and tailor your pre-adverse and adverse action letters, to our adjudication services, our managed adverse action letter services. All of these tools are at your disposal. Let us know if you'd like more information when you complete today's survey. That is our criminal history reform section. Keep getting your questions in, by the way. I'm seeing great engagement with Nicole here. Let's shift gears and talk about two pillars of modern employment law that now travel together. That's pay equity and pay transparency. Pay equity, it focuses on outcomes. What does it do? Well, it aims to close wage gaps by preventing discriminatory pay practices. At its core, it's a simple idea. Past pay should not dictate future opportunity. That's why salary history bans exist. They cut the cord between what someone earned before and what they should earn now. Pay transparency focuses on visibility. These laws require employers to disclose salary ranges and job postings upon request. The goal here is to make pay decisions earlier to understand, easier to challenge, and harder to hide. Let's take a look at a map. This map shows where salary history bans are now in effect. We're up to 29 jurisdictions and counting. In practice, these laws do three things. You can't ask about prior pay, you can't rely on it to set compensation, and you can't use it to justify why one candidate earns more than another. You can still ask about salary expectations. Questions like, what are you hoping to earn in this role? Or does this range align with what you're looking for, remain compliant in all jurisdictions? That distinction, it really matters. So one question is looking backwards, the other is looking forwards. That nuance is important for recruiters and hiring managers, because scripts that you used 5 years ago, they can now create risk. Let's turn to pay transparency. This map highlights the jurisdictions that require employers to include salary ranges directly in job postings. In many places, disclosure is no longer something you do later in the process. It has to be visible up front. Most of these laws require that the range reflect what you, quote, reasonably expect to pay for the role. That means no placeholder numbers and no artificially wide ranges designed to attract clicks. You need to be specific. Transparency laws assume that if you post a range, you can explain how you got there. You have to show the math. This chart shows an important shift. Every jurisdiction listed now requires wage disclosure in the job posting itself, not in a follow-up email, not during the interview, right in that job posting. That alone should prompt a review of your job templates. So let's walk through what's changing. Illinois, New Jersey, Minnesota, and Vermont already have laws in effect or coming online. Several pair pay transparency with broader equity initiatives like job classification reviews or EEO reporting. Transparency often acts as the gateway to deeper scrutiny. Massachusetts and Cleveland passed laws that took effect this fall. Massachusetts applies statewide to employers with 25 or more employees. Cleveland applies to roles based in the city. That distinction matters for hybrid and remote roles. A fully remote job may fall outside of Cleveland's role, but a Cleveland-based role, that does not. Columbus follows in 2027 with similar requirements, but notably does not require employers to disclose benefits. California already has one of the most expansive pay transparency laws in the country. What changed on January 1st, 2026 are clarifications and expansions. The amendments tell us that we need to consider remote job postings, we need to consider job transfers, and reinforce the requirement to disclose benefits, not just pay. You have to include benefits now as part of your disclosures in California. Delaware comes online in 2027, but it's worth flagging now. The law covers remote work, and it requires disclosure both of pay and benefits. If you're building long-term hiring infrastructure, this belongs on your roadmap today. So what's the big picture? Well, it's this. Regulators now expect employers to show their math. Posting a range is not enough. You need to understand how it was set, whether it aligns with internal pay bands, and whether it holds up across similar roles. Remote work complicates everything. If a job can be performed from anywhere, You may trigger transparency obligations based on where a candidate lives, not just where your office sits. That feasibly means that if you consider remote hiring, you need to comply with pay transparency laws, full stop. Let's move from pay transparency to pay data reporting, where the conversation shifts from what you must show publicly to what you report behind the scenes. Two developments matter most right now, California and New York City. You see that on the screen. Starting with California, Senate Bill 464 significantly expands pay data reporting beginning in 2026. Employers must now report across 23 job categories tied to SOC codes. That requires more precise workforce coding and tighter coordination with HRIS and payroll. The law also mandates separate storage of demographic data, so you can't simply bundle everything together. Systems need to link data accurately while keeping demographic fields segregated from the rest of your pay data. Now to New York City. In late 2025, the City Council enacted a pay data and equity study law over a mayoral veto. Really interesting politically. The mayor vetoes it, the City Council ends up reinstating it. It applies to private employers with 200 or more New York City employees and mirrors the structure of old EEO1 component 2 reports. Employers have to submit annual pay data and conduct a recurring pay equity analysis, complete with documented methodology. If this sounds like a heavy lift, it is. I'm not going to sugarcoat this here. I would also say, don't assume that this sort of pay data reporting is going to stay isolated to New York City. We're seeing these pay data reporting mandates gain momentum. They're being increasingly framed as enforcement tools and not as transparency exercise. So I say that the smart approach is to treat pay data reporting like financial reporting. You have to have it structured, it needs to be auditable, and it has to be defensible. Get your ducks in a row as it relates to pay data reporting. I know that's new for a lot of us. So let's bring this home. Pay compliance today is not a checklist. It's an ongoing cross-functional discipline. Salary history bands require you to audit recruiter scripts, onboarding forms, and even employment verifications to make sure past pay is not creeping into the process indirectly. Pay transparency requires you to align what you publish with how you actually pay. Placeholder ranges and overly broad bands invite scrutiny. Remote work multiplies the risk. A single posting error can trigger obligations in multiple jurisdictions if location assumptions are wrong. And pay data reporting raises the stakes even further. Regulators are no longer asking questions, they're simply demanding data. The takeaway here is simple. Pay equity compliance lives at the intersection of people, systems, and processes. One outdated job template, one untrained recruiter, or one misconfigured vendor workflow that can undo months of careful planning. The employers who get this right, they connect the dots early and they build systems that can withstand scrutiny. That's the Compliance Playbook lesson for pay equity and transparency. Let's shift to a narrower but high-risk area of employment law. That's restrictions on an employer's access to a worker's credit history. We don't talk about this very often, but it's really important. I think you're going to have a few questions about this one. Credit reports are one of the most tightly regulated and most misunderstood tools in background screening. Across the country, states and cities have built a patchwork of laws that sharply limit when employers can request or use credit history. You see that there on the screen. And unlike some other areas of screening, these laws, they don't move much. Early on they did, they don't now. When a jurisdiction restricts credit, it tends to stay restricted. Until recently, the last major update came out of Puerto Rico several years ago. The map had been relatively stable. That all changed when New York stepped in, which we're going to cover next. But before we get there, it's important to understand how narrow these exceptions really are. Most credit laws allow checks only in specific circumstances. Think executive roles, positions with signatory authority over bank accounts, jobs with regular access to confidential financial information or trade secrets. Even then, the exception has to match the actual duties of the role, not the title. Colorado is a great example of how layered this can get. If an employer takes adverse action based on credit history, the employer has to explain the reason in writing, not just provide an FCRA notice, but explain how credit factored into the decision. You have to modify your adverse action process. That requirement alone changes your behavior. So what is the takeaway here? I think it's relatively straightforward. If you use credit reports, you are operating in a high-risk zone. You need to know exactly why the role qualifies, and you need to be prepared to show your work. You can still use credit reports, just use them in a smart way. Now let's talk about New York, because this is where the landscape shifts. Most HR and compliance teams already know that New York City has restricted credit checks for years. The Stop Credit Discrimination in Employment Act, SCDEA, has been in place since 2015, and enforcement has been active. You know, the regulator there is very active. Employers must document any exception they rely on and produce that documentation to the city's Commission on Human Rights when they ask for it. What's new is that the state is following the city's lead. Senate Bill 3072 takes effect April 18th, 2026, in a few months, and it extends similar restrictions statewide. It amends the general business law to prohibit most employers from requesting or using consumer credit history for employment decisions. That includes hiring, promotion, compensation, or other terms of employment. The definition of credit history is broad. This is where it's interesting. It's not just limited to credit reports or scores. It includes bankruptcies, late payments, collections, liens, even self-disclosed credit information. If it relates to creditworthiness, it's covered. Even if the candidate self-discloses to you, you didn't even ask for it. There are 8 exceptions. You see them there on the screen. They're role specific and have to be interpreted very, very narrowly. Here's the critical point. Even if an exception applies under the state law, New York City's stricter standards still govern for city-based rules. The state law explicitly allows stronger local protections to remain in effect. So employers are going to need to think in layers. State law, it sets the floor. City law may raise to the ceiling. The practical step is not complicated, but it's urgent. You're going to want to audit your screening packages, identify where credit checks are still being ordered, confirm whether those roles truly qualify, update your job descriptions, and train your recruiters and hiring managers. All right, customers, expect to hear more from us as guidance develops before April. We're going to certainly be in touch. I'll certainly keep you updated on LinkedIn as well. So let's close this section with the bigger picture. Credit checks feel familiar, which makes them dangerous. Employers often assume that financial responsibility equals permission. The law doesn't work that way. Many jurisdictions restrict credit use outright. Others allow it with notice, documentation, or role-specific justification. Some laws, they apply not just to applicants, but to current employees as well. And remember, credit history is defined broadly. Information that a candidate volunteers can still be off limits if the role does not qualify. So the safest approach, that is very measured and intentional use. Review where credit appears in your screening packages, confirm that an exemption truly exists, document your reasoning, and train your teams to understand that credit is the exception, not the rule. Let us know if you need any help adjusting your screening packages when you complete today's survey, and check out our credit white paper in the resources section of the webinar. It's included there. I also covered New York City's law, both in that 2025 year in review article, as well as separately on Forbes and in the HireRight blog. So let's pivot to cannabis reform. I'm going to use the terms cannabis, marijuana, and THC interchangeably, just like I do in my writing. They all point to the same substance. Cannabis, THC, marijuana, all the same thing. What really matters here is the legal consequences for employers, because this is one of the fastest moving and most fragmented compliance areas we deal with. Get your questions in. I know that you're going to have questions about marijuana. Let's start with medical marijuana. This map shows whether states require employers to accommodate medical cannabis use. The red states, they say no, employers don't have to accommodate use. Aqua states impose anti-discrimination protections, which means that accommodation may be required unless it creates an undue hardship for the business. Blue states, those are silent. That leaves employers in kind of an uncertain legal territory. And purple highlights Philadelphia and Pittsburgh, both of which ban pre-employment testing for medical cannabis users. Again, Philadelphia, Pittsburgh, you can't test for medical cannabis. Across the board, federally regulated and safety-sensitive roles usually sit outside of these protections. So what does that mean? DOT roles, positions tied to federal contracts, and certain public safety jobs, those are all exempt from the scope of these particular laws. Let's zoom in on Kentucky and Texas. Kentucky's medical cannabis program took effect earlier this year. For most employers, the practical impact is minimal. The law doesn't require accommodation, so while access is expanded, employer obligations largely didn't change. This is a good moment to revisit your policy language and make sure it lines up with the current law. Anytime there's a new law, you should revisit your policy statements. Texas, that's a little bit of a different story. Texas has technically had a medical marijuana program in place for about a decade, but it was so narrow that many employers barely noticed it. That kind of changed as of September 1st, 2025. The state expanded its compassionate use program. There are more qualifying conditions, more dispensaries, new products like lotions, and a higher THC cap of 10 milligrams per dose. What didn't change is employment protection. Texas law still does not require accommodation. Cannabis remains illegal under federal law, and the ADA does not require any accommodation or protection of cannabis use. But here is what I want you to think about. Here's where the risk, in my opinion, creeps in. The underlying medical conditions are often protected disabilities. So when marijuana is quote unquote prescribed for an underlying condition, that underlying condition is often protected. So as access expands, employers should expect more failed tests, more accommodation requests, and more litigation testing around the edges of these laws. Again, marijuana is still federally illegal, so you don't have to accommodate it, but you may see more accommodation requests for underlying disabilities. That means that now is the time to revisit THC testing, designate a clear internal process for handling accommodation requests, and slow down before taking adverse action against somebody enrolled in a medical marijuana program. Let's head to Minnesota, where the state added a procedural twist that employers really need to understand. So recreational marijuana has been legal in Minnesota since 2023. That law already limited THC testing unless a role fell under a defined exception like DOT coverage, safety sensitive work, or federal contracting. Senate File 237, that tightens the rules further. If you are allowed to test in Minnesota and you plan to discipline or terminate a registered medical cannabis patient based on a positive test result, you have to provide them with written notice at least 14 days in advance. That notice has to identify the specific federal law or regulation involved and explain what federal benefit, contract, or license is at risk. You have to be ultra specific here. General safety concerns, they're not enough. You have to have that legal hook. There is a narrow exception if waiting itself would violate federal law or jeopardize a contract, but that exception demands strong documentation. You have to explain it. For most employers, this isn't going to change much. Most employers already remove THC from their panels, but employers in regulated spaces, think DOT or energy, healthcare maybe, they need to update policies. They need to train HR teams on the notice requirement and document every decision tied to federal law. Minnesota didn't ban testing outright, but it has demanded transparency and a procedural pause. That is a concept that other states may borrow. We'll see what 2026 brings to us. Now let's zoom out to recreational cannabis more broadly. This map shows where adult use marijuana is legal and how that affects testing. In red states, employers can still test for THC and act on positive results. In aqua states, laws restrict adverse action based solely on a positive test. In blue states like California and Washington, pre-employment urine testing is effectively off the table because it detects inactive metabolites, not impairment. Employers either need to drop THC or move to oral fluid testing. Again, be cognizant of what you're doing in California and Washington. In purple states like New York and Minnesota, pre-employment testing is generally prohibited unless a specific legal exception applies. Be cautious in New York and Minnesota. Let's now pivot and talk about two federal developments that closed out 2025 with a bang, and they could reshape testing decisions going forward. A lot going on at the federal level, but I think it's particularly interesting. First, President Trump signed an executive order directing the Attorney General to finalize marijuana's move from Schedule 1 to Schedule 3. This signals a policy shift, not an immediate compliance change. What does this mean? Marijuana remains prohibited under federal law, and DOT testing requirements, they remain fully intact. But if rescheduling moves forward, employers in regulated industries will face new questions about prescriptions, accommodations, and whether marijuana-based medications start to resemble other Schedule 3 drugs. It'll be really interesting to see how this rescheduling advances. The second development may have more immediate impact. In fact, I know it will. Congress passed H.R. 5371, which rewrites the federal definition of hemp. This is actually the bill that refunded the government and caused the government to reopen. This was buried in H.R. 5371. The old rule focused only on Delta 9 THC and left room for products like Delta 8, Delta 10, and THCA flower. That door just closed. What does that mean? Those gummies that we see at wellness stores or online that might help us sleep or offer us pain relief, if they have an intoxicating effect, they're going to go away. The new law lowers THC thresholds. It bans synthetic cannabinoids, and it directs agencies to identify substances with effects similar to THC. Most hemp-derived intoxicants, they're going to become federally illegal when the law takes effect later this year, November 2026. That matters for employers because the common defense that we saw from candidates that said, it was legal hemp, I just took a gummy, that's going to disappear. For DOT regulated employers, these developments reinforce existing obligations rather than loosen them. This is going to help us from a drug testing perspective. It's going to hurt us from a pain relief perspective, but that's what's happening from a federal government perspective in the world of THC and marijuana rescheduling. So let's close this section with the big picture. Cannabis compliance is evolving and diverging. Texas expanded access without expanding protections. Minnesota layered in procedural safeguards. Some states ban testing outright. Others regulate how results can be used. Federal law continues to move in parallel, not in sync. Employers need tailored drug testing policies, clear manager testing, and designated points of contact for accommodation requests. And when the stakes are high, it's always worth slowing down and talking to counsel before taking adverse action. Because in today's cannabis landscape, the real risk is not just what you test for, it's how you respond when somebody tests positive. Have a plan in place. Let us know if you need help adjusting your drug testing panel in today's survey. And I wrote an article that offers a good overview of marijuana laws. I linked to it in the resources section of this webinar, so check it out. That is everything on cannabis. Now, it's time for my favorite part of the webinar, you be the judge. This is where I give you a real-world fact pattern, and you decide how the case should come out. No trick questions here, just the kind of scenario compliance teams and screening providers wrestle with every single day. So let's get into it. I'm calling this one listed for life. I'll tee up the facts for you. A candidate applies for a healthcare adjacent role and receives a conditional offer. As part of the process, the employer orders a government-sanctioned search as part of the background check. The report comes back showing the candidate is currently excluded from participating in federally funded healthcare programs. It's a real exclusion, it's active, it has real legal consequences. So far, pretty uncontroversial, right? But then the report does something else. It explains why the candidate is excluded. According to the report, the exclusion is tied to a nursing license revocation that occurred in 2011, more than 7 years before the report. So what happens? Well, the employer rescinds the offer. What happens after that? Of course, the candidate then sues the screening provider under the Fair Credit Reporting Act, arguing that the report unlawfully included obsolete adverse information. That is the setup. So here's what I want you to consider. Did the background report violate the FCRA? I'm going to open up the poll question here and give you a few seconds to get your answers in. So lock in your answer. Think about this like a compliance team. Think about it like a screening provider. So the exclusion, it's current and enforceable, but those underlying license revocations, that's more than 7 years old. So how does this shake out? Do we have a violation, no violation, full violation? Give you a few seconds to get your answers in. Let's see, we've got only about 5% of you returning an answer. I'll get to the answer when we get around 40, 50% of you getting in. So think about this, no violation, partial violation, or yes, both the exclusion and its basis are too old to report. Just a few more seconds, we're at about 30% in. Once we get a little over 40, I'll go ahead and close out this poll. All right, let's see what everybody thinks. All right, so The majority of the audience think that this is a partial violation. The exclusion is reportable, but the old license and revocation are not. Well, let's see how the court decided. And you are correct. Here's how the court landed. The judges drew a clean distinction between status and story. First, the exclusion itself. The court said that it was fair game. It was ongoing, legally operative, and directly relevant. Recording the active exclusion, it didn't violate the FCRA. But then came the explanation. The nursing license revocation, that happened back in 2011. That was a separate adverse event. And under the FCRA, each adverse item has its own 7-year reporting clock. By including that outdated revocation as part of the explanation, the report crossed the reporting line. So you were right. The correct answer is a partial violation. Now here's the twist, and this is why this case really matters for compliance professionals. Even though the court found a statutory violation, the screening provider still won the case. Why? Because the law was genuinely unclear at the time. There was no prior appellate guidance on how to handle this exact scenario. The court said that the provider's interpretation was reasonable, which meant no negligent or willful violation. That brings us to the real lesson. This case is about report design. Current disqualifiers may be reportable, but how you explain them matters, including information that exceeds the FCRA 7-year adverse reporting period in a narrative explanation that provides that historical context. That can quietly turn a compliant report into a legal problem. So accuracy alone, that's not the finish line. How you present it matters. And for employers, that distinction can make all the difference. This was a little different from us, but I hope you enjoyed our You Be the Judge case. And for our healthcare customers, I hope this provides a little bit of insight into why we report as we do on our sanctions reports. I found this one particularly interesting. All right, let's shift into a space that is evolving faster than almost any other area of employment law: AI, privacy, and emerging technology. And the common theme here is this: regulators are no longer asking whether technology can be used, they're asking who owns the consequences when it is. Very interesting question to ask. Let's start with privacy. This map shows states with comprehensive privacy laws, both those that are already in effect and those that are coming online soon. Laws that went live in 2025 are highlighted in aqua, and upcoming laws are in purple. One important reminder for this audience: all of these laws exempt data regulated under the Fair Credit Reporting Act, the FCRA. That means background checks conducted through HireRight and similar providers sit outside of these privacy statutes and remain governed by the FCRA, not subject to these privacy laws. But that exemption is not a free pass, at least not in California. Think about everything else in your hiring ecosystem: applicant tracking systems, career sites, onboarding platforms, HR tools, workspace monitoring tools. Those systems collect and process personal data that is not covered by the FCRA. So employers need to know where data lives, how it's used, and whether vendors are complying with state privacy requirements. In California, employee data is fully in scope. Now, let's shift to AI regulation. This map tracks the growing number of state and local laws aimed at automated decision-making, especially in employment. You've likely heard of a few already. New York City's Local Law 144, it requires annual bias audits and advance notice to candidates. Illinois, their AI Video Interview Act mandates notice and consent. And we're going to talk about California, Colorado, and Texas in a few seconds. What we're seeing is a clear shift. Lawmakers are moving away from abstract principles and towards concrete obligations: disclosure, audits, consent, documentation, and liability that flows through vendors to employers. That's the question we're answering. California illustrates this shift better than anywhere else. The California Civil Rights Department's new regulations took effect on October 1st, 2025. These rules do not create new audit mandates, but they clarify liability. This is what I'm talking about. Automated decision systems include resume screeners, scoring tools, ranking algorithms, and filters. If those tools influence employment decisions, they're covered. The takeaway is simple: employers may not use ADS tools, automatic decision systems, or selection criteria that discriminate based on protected characteristics. These rules don't create new duties, but they clarify that California's anti-discrimination laws apply to emerging technology. In other words, discrimination by a bot is treated no differently than discrimination by a human. Now, let's zoom into Texas. The Texas Responsible Artificial Intelligence Governance Act, or TREGA, took effect on January 1st, 2026. It's broad in scope, but its immediate impact on private employers is limited. The law primarily applies to public agencies and healthcare providers. It does not mandate audits. It does not mandate impact assessments or disclosures for private employers using AI in hiring. Still, TREGA sets important boundaries. It prohibits intentional discrimination through AI. Liability, it only attaches when intent is shown. Disparate impact alone doesn't trigger a violation. So while Texas may be lenient today, it's sending us a signal. It's telling us to review our AI tools, make sure they're explainable, lawful, and documented. Trends, they rarely stop where they start, so we'll see if Texas's model takes on. New Jersey takes a very different approach. In December of 2025, the state finalized rules under the Law Against Discrimination that directly addresses automated decision tools. New Jersey made explicit what many employers suspected. A neutral hiring practice can still violate the law if it disproportionately harms protected groups. That includes AI. The rules identify 3 points where bias can creep in. Design, when tools rely on biased inputs, training, when models learn from skewed data sets, and deployment, when employers use tools inconsistently or without testing. If a practice produces a disparate impact, the employer must justify it with empirical evidence, not just assumptions, not just intuition, empirical evidence. And here is the critical shift. Employers using automated tools must test them for bias. Failure to test combined with discriminatory outcomes, that creates liability. In New Jersey, ignorance is no defense. If you can't prove your system doesn't cause harm, you could be liable. Now let's talk about Colorado. The Colorado AI Act goes live on June 30th, 2026. It's the first cross-sector AI law in the country, and it focuses on high-risk systems that influence consequential decisions, including hiring, housing, education, healthcare, and legal services. AI that results in unlawful differential treatment based on protected characteristics, it's banned. The law also creates obligations for both developers and deployers. Developers must disclose how systems work and flag risks. Deployers must conduct impact assessments, manage risk, track outcomes, and document safeguards. Your vendors, they're developers. You, employers, are deployers. You, employers, are deployers. Everybody must publish statements explaining how they avoid algorithmic discrimination. If you haven't thought about your statement, and if you haven't started drafting your statement, start drafting it now. You're going to have to publish it by June 2026. For employers using AI in hiring or promotion documentation, it's no longer optional. You need to get your ducks in a row now. Now let's shift to the federal stage because Washington is pushing back. On December 11th, 2025, the president signed an executive order directing federal agencies to challenge state AI laws that are viewed as overly restrictive. The order targets laws that allegedly force AI models to produce distorted results or impose expansive disclosure obligations. A new DOJ task force will pursue litigation under the Commerce Clause and the First Amendment. States that continue enforcing these laws could risk losing federal funding tied to infrastructure and broadband programs. But until Congress acts, employers are stuck between rising state requirements and the federal effort to rein them in. It'll be very interesting to see how this shakes out. So let's close this section with what matters most. AI is no longer theoretical. It's embedded in hiring workflows right now, and states are not waiting for Washington. New Jersey demands bias testing and proof. California assigns direct liability to you, employers. Colorado requires governance and documentation. Texas offers flexibility, but with guardrails. The common thread here is ownership. Whether you build, buy, or borrow AI, regulators expect you to understand it, test it, document it, and explain it. Compliance starts now, not when Congress acts, not when a vendor updates its contract, now. If AI influences employment decisions in your organization, treat it like it's yours, because under the guise of regulators, legally, it is. let's open the compliance playbook one more time and turn to I-9 and E-Verify. This isn't a new topic, but it's one that's moving quickly again. We've got two buckets to cover. First, some technical updates that affect day-to-day workflows. Second, a broader shift in enforcement that raises the stakes for getting those workflows right. So let's start with the mechanics. USCIS released a new version of Form I-9 dated January 2025 with an expiration of May 31, 2027. On the surface, the form looks familiar, but there are a few changes worth flagging. Checkbox 4 in Section 1 now reads an alien authorized to work, which aligns the form with statutory language. Two List B document descriptions were revised, and the DHS privacy notice and instructions were tightened to be more legally precise. You can still use that August 1st, 2023 version, but here's where employers are getting a little tripped up. Some systems are incorrectly showing that older form is expiring July 31st, 2026. If that's what your system displays, update it by then to avoid audit issues. E-Verify, it also changed on April 3rd of last year. The system now mirrors the new I-9 terminology. Even if your form still says non-citizen authorized to work, E-Verify requires you to select an alien authorized to work when prompted. The system's going to relabel the status automatically as things change. This applies across all E-Verify, E-Verify Plus, and web services accounts. The interface control agreement, that didn't change, but developers should update terminology where possible. These are small edits, but they reflect a bigger and larger theme that we're seeing again and again. USCIS wants consistency, and in an enforcement-heavy environment, precision matters. So let's zoom out and talk about enforcement. On day one of the current administration, multiple executive orders signaled a return to aggressive immigration enforcement, expanded deportation priorities, increased ICE worksite activity, reduced funding for sanctuary jurisdictions for employers. That translates into more I-9 audits, more unannounced site visits, and steeper penalties when things go wrong. Your I-9 process, it needs to be tight. Section 1 completed by day 1, Section 2 within 3 business days, documents physically inspected as applicable, forms stored securely and separate from personnel files. E-Verify compliance matters too. Accounts have to stay active. Users need to complete required tutorials. We're seeing that a lot. Our customers ask to prove up their training. Participation and rights posters must be displayed in English and Spanish. And you should be ready for a visit. Designate trained points of contact. Make sure employees understand their rights, including the right to remain silent and request an attorney, and involve legal immediately if agents show up. Be prepared. This is not the moment to be reactive. Have a playbook in place. Now let's turn to an area that's creating real confusion right now. That's work authorization for individuals with temporary protected status and humanitarian parole, TPS. In recent weeks, federal courts have stepped in repeatedly to block or delay the termination of TPS designations for Venezuela, Nepal, Honduras, and Nicaragua. In some cases, injunctions were issued just hours before DHS deadlines. Courts have questioned whether DHS followed the Administrative Procedures Act. Others focused on irreparable harm to workers and employers. For employers, this creates uncertainty. Court orders may preserve status, but DHS systems and guidance, they don't always update in real time. This is especially tricky with employment authorization documents in categories C19 and C11. An EAD that looks expired may still be valid because of an automatic extension. An EAD that looks valid may not be, depending on litigation outcomes. That puts employers in a bind. Reject a valid document and risk a discrimination claim, accept an invalid one and risk an I-9 violation. What do? Well, the only safe path is caution. Track TPS updates by country, consult counsel before rejecting or re-verifying authorization, and double-check tentative non-confirmations in E-Verify, where underlying records may lag behind court orders. This is one of those moments where careful documentation and restraint, they matter so much more than speed. Layered on top of that, confusion is a change to EAD validity periods under HR 1. For parolees in category C11, initial work authorization is now valid for up to 365 days or until the parole period ends, whichever comes first. For TPS holders in categories A12 and C19, the same 365-day limit applies, or the duration of TPS is shorter. As of July 22nd, 2025, renewal applications also face new caps. Automatic extensions are limited to 1 year or the length of TPS, whichever is shorter. The era of multi-year automatic extensions, that's largely over. Employers should expect more frequent re-verification obligations. And here is another E-Verify update that flew under the radar but carries real compliance impact. DHS added a new field to the E-Verify status change report called revoked document number. This allowed employers to see exactly which EAD DHS had revoked after a case was submitted. If the revoked number matches the EAD used on Form I-9, the employer must re-verify using Supplement B. If it doesn't match, no action is required. This eliminates the guesswork. Employers can now verify with confidence instead of relying on assumptions. So that is one positive update. So let me pull this all together for you. First, confirm that you're using the correct I-9. The current version is dated on January 20th, 2025, and valid through May 2027. But don't assume your system is right. Check expiration dates before July 31st. Second, prepare for enforcement. ICE activity is up. Penalties are higher. FDNS visits are increasing. And if you don't have an audit playbook, build one now. Finally, pay close attention to work authorization documents. TPS and parole status is fluid. Auto extensions are shorter. Revoked documents are now visible in E-Verify. Immigration compliance is moving fast again, and mistakes are expensive. So make sure your playbook is in order. With that, before we wrap up, I want to leave you with a quick reminder about the resources available to you. If any part of today's discussion sparked questions or deserves a deeper dive, check out the HireRight Resources Library or blog, along with my Forbes compliance articles. And if we're not connected yet, scan that QR code on the screen and find me on LinkedIn. I post a short compliance video every week breaking down what's changing and what it means for employers in real time. With that, that brings us to the end of the prepared portion of today's webinar. We're going to transition now into that brief after-hours Q&A. If you joined us for SHRM or HRCI credit, you've officially met that 1 hour requirement, so feel free to drop off whenever you need to. But before you do, please make sure to complete the feedback survey. I genuinely read all of these. They're my report card. I take them very seriously, and they really do help shape how we build future sessions. You're going to receive a follow-up email next week with your credit certificate and a link to the recording so you can revisit any section or share it with your team. For those staying with us, let's jump into those questions. We're going to invite Nicole into the conversation. We're going to keep the Q&A focused and aim to wrap within about 10, 15 minutes max. So again, stick with us if you can. Let's bring Nicole in and keep getting your questions in, by the way. Nicole, any themes from the webinar that you want to jump into straight off the bat?
I would say the biggest theme and the place we probably should start is Philadelphia. We got a lot of questions around Philadelphia. So we'll jump in right there with what I think most people are probably wondering. Do we expect the notice or summary of rights to be issued soon? Do we have any information on when they may issue the documents that they are to be issuing?
As I mentioned, I did reach out to the executive director of the Philadelphia Human Relations Commission. In my exchanges with the executive director, I understand that they are meeting internally to discuss the documents that they are supposed to produce. So that includes the notice as well as the individualized assessment template and any other associated documents. My understanding is that they were meeting at the end of last week and would need to engage other individuals in order to come up with those documents. So my expectation is that they will issue those documents at some point. When, we do not know. I expect that those documents will be published to the Philadelphia Human Relations Commission's website under their documents or resources section. HireRight customers will of course keep you updated. But until then, we're in a waiting game. As far as enforcement guidance is concerned, I would say that they can't enforce, my intuition tells me that they can't enforce provisions that they haven't acted on. I think the most important thing right now is to conduct those individualized assessments under the city's criteria, which is basically the green factors, and provide those individualized assessments to those applicants now. Adhere to that 10-day waiting period and expect more guidance from the commission, I would say hopefully within the next several weeks.
All right. And then the next pretty common question we got on Philadelphia is around when it applies. Is it work location? Is it where they live? What happens if those two are different? How are employers to figure out if it applies to them or not?
It's any nexus to work within Philadelphia. So if your applicant will work within Philadelphia, whether physically or remotely, then the Philadelphia human rights law will apply. Their ban the box law will apply. There is no difference in scope than the existing law. So I would say don't change what you're doing now. Again, the only changes that Philadelphia is really substantively bringing to us, besides the look back period, is the requirement that send that individualized assessment 100% of the time, and that you also provide that notice. That notice is still forthcoming. Nicole, I'm going to put a pause right there so that we can officially end the prepared portion of today's session, and we'll go into our after hours Q&A session now. So thanks everybody who joined us for that SHRM and HRCI credit.
All right, one more question on criminal history, and then we'll move on to pay and pay equity. So this question is really around what shows up on background reports. More specifically, should employers expect to see sealed and expunged records in background reports? And if so, how are they supposed to know that they are sealed or expunged?
Great question. So what I was alluding to during today's conversation is this gap between when a law is effective and when those crimes, that criminal history is actually sealed or expunged. Lawmakers are very well intentioned, so they'll set an effective date. Let's just say an effective date is January 1st, 2026. They passed the law in July of 2025. They set an effective date of January 1st, 2026. What has to happen between when that law was passed and the effective date, in theory, is that some agency within the state has to comb through all of those criminal records and identify what criminal records would be subject to automatic sealing or expungement, and then actually take action to remove those records from the court's public indexes. That is a monumental task that is often misunderstood by lawmakers. Again, very well intentioned, but the execution is flawed. What means is that effective date passes, January 1st, 2026 comes about, and those crimes that should have been sealed or expunged in many cases were not, because the court was unable to do so within the allotted time. What that means is those crimes may continue to appear on background reports, creating this compliance gap or gray area for you as employers. Because the crimes are still technically reportable, they're still in the court's public indexes, but you may be unable to consider them at that point. We don't really know how this works, right? Because technically, for a candidate to be eligible for expunsion, automatic expunsion, it requires that they meet a certain test. It requires that they remain crime-free for a period of time, and it requires that their criminal history does not fall into an exempted category. That's all incumbent on the court to figure out. It's not something that a background check provider can figure out, for example, and it's not something that you likely can figure out either. So you'll have to develop plans as to how to assess that particular criminal history that may be reported lawfully until a court is actually able to seal or expunge it. I get that this is a really difficult position to be in, but this is one where you're going to want to have an escalation path where you probably involve your legal counsel in understanding whether or not you should consider any of that criminal history that technically should be sealed or expunged, but isn't as a result of operational reasons.
All right, let's move on to pay transparency and pay equity. So this is kind of similar to one of the questions that we talked about for criminal history, but the question is for pay transparency laws. Are we looking at the number of employees within the state that has the law, or the number of employees all over? So do we have to count everybody, or just who is in that actual jurisdiction where the law applies?
Lawyerly answer, it depends. So unfortunately, this is one of those answers where you're going to have to dig into the particular statute or ordinance as applicable. Some states say that it's applicable to any employer that have X number of employees within the state or within the city. Others say it's all together. So there isn't a single answer. We do have a pay equity white paper, which we're in the process of updating, that covers that to some degree. I've also linked within that 2025 year in review compliance article to all of the pay equity and transparency jurisdictions. You can click through to those links and figure out what the scope of enforcement is. I would say if you're at all questioning this, just take your total employee count. I mentioned this though during their webinar. I think the biggest takeaway here though is that for a lot of states, any remote work would cause that state's law or city's law to become effective. So if you hire remote anywhere, and anywhere could be one of these pay equity or transparency jurisdictions, then you probably have to comply with pay equity and transparency at a minimum. It's a very difficult position for employers to be in, but I think that's the truth of the matter.
All right, let's do one more. We'll move on to I-9 and employment eligibility. This is a really good question that I really and truly don't know the answer to. So you mentioned keeping up to date with EAD rules. Do you know of any websites employers could bookmark or review, or any resources that are available to help them do this?
So for HireRight customers, we've been producing a almost weekly update to Compliance Central that covers one of our law firm partners, Littler Mendelsohn. Littler is covering this within their own blog, where we're republishing that within Compliance Central as well. There are other law firms that are keeping matrices that track these particular issues. So I would say one of the outlets again is Littler, but there are other law firms, that have matrices out there that are tracking these particular dates. And it is a moving target, so it's very important to look at it at least weekly. Again, for HireRight customers, we're producing this on Compliance Central.
All right, and I think that pretty much wraps us up.
Amazing. Well, thank you so much to our audience for the engagement. As always, incredible audience. Keep getting your questions in. We'll look at these after today's session. And that really does wrap today's session. So the full webinar will be available soon in the HireRight Resources Library, and your credit details will be emailed next week. So thank you again for spending a part of your day with us. I hope today's discussion felt practical, relevant, and relevant and useful to your role. Please do not forget to complete that exit survey. Your feedback directly influences how these webinars evolve. We're going to be back in April with our first quarterly compliance review of 2026. Until then, I hope you're going to stay connected with us on Forbes, the HireRight blog, and LinkedIn. On behalf of Nicole, myself, and the entire HireRight team, thank you. We truly appreciate your time and your trust, and we'll see you in the spring.